Welcome to this training series on Article 81 Guardianship. In this series, you will learn more about guardianship in a medical setting, who it's for, its limitations, alternatives, and specifics about medical decision-making and how to work with the guardian. I'm Dina Schwartz, Chief Initiatives Officer at Project Guardianship. Before we start, let me tell you a little about our organization. Project Guardianship provides person-centered care for older adults and individuals living with disabilities and mental illness who need help making decisions. We also transform the systems and services that support them to promote independence, preserve dignity, and advance racial and social justice. As court-appointed guardian, we specialize in keeping people in their homes, out of institutions, and when possible, restoring their rights. We also provide education, do research, and advocate for better policies and practices in our guardianship system and in the services that can help prevent unnecessary guardianships. For more information about us, go to projectguardianship.org.
Hi, I'm Jasmine Ramig, Training and Education Staff Attorney at Project Guardianship. In this video, we'll explain the basics of Article 81 guardianship, how a judge determines that someone is incapacitated, and describe the court process involved. A guardian is a person or an agency that has the authority to make decisions for someone who can't meet their needs and is at risk of harm. Guardianship is a legal arrangement put in place by a judge and requires a court process that includes a full hearing and a lot of paperwork. A guardian is a surrogate decision maker. The guardian's decision-making powers depend on the person's needs. A judge will determine which decisions a person cannot make on their own. Those decisions will ultimately be up to the guardian. However, the guardian still needs to consider the person's preferences, wishes, and values. New York actually has two different types of adult guardianship. In this series, we are only covering Article 81 guardianship. It comes from Article 81 of New York's mental hygiene law. The other type is known as 17A guardianship. It requires a diagnosed intellectual or developmental disability or traumatic brain injury. A 17A guardian is automatically given all decision-making power over an individual. On the other hand, an Article 81 guardian will only be given the power to make decisions that the person cannot make for themselves. For example, if a person can manage their personal needs like bathing, dressing, and eating, but they aren't able to pay their bills, an Article 81 guardian would only be given the power to make decisions about the person's finances. So someone with an intellectual or developmental disability or a traumatic brain injury could have either type of guardian. But Article 81 provides more flexibility and allows a person more autonomy. If you'd like more information about 17A guardianship, please consult the links in the companion PDF. Let's talk about who gets a guardian. The person subject to a guardianship proceeding is sometimes called an alleged incapacitated person, or AIP for short. For the purposes of this training, we'll just refer to them as the patient. One important note is that when we are discussing incapacity, we are using it as a legal term with a very specific legal definition. We are not using it as a medical term. Before a judge can appoint a guardian, they need to find four things first. 1, the patient has unmet personal and/or property needs. 2, the patient is at risk of harm because of these unmet needs. 3, the patient doesn't understand the consequences of being unable to meet their own needs. And 4, there are no other services or tools available to meet their needs that are less restrictive than guardianship. Now let's look at these in more detail. Unmet needs is simply showing a person cannot do what's necessary to meet their basic needs. The court will often refer to activities of daily living, or ADLs for short. For example, can the patient bathe, dress, prepare meals, or address medical concerns on their own? Can they pay bills, file taxes, and protect their personal information? This means having diagnoses such as dementia, mental illness, or disability alone does not automatically mean someone needs a guardian. There must be specific needs that aren't being met. Next, the court will look at whether the patient is likely to suffer harm because they are unable to meet their own needs. Let's say a patient is unable to manage their finances and they haven't paid rent in several months. Now they're facing an eviction action. In this example, a judge may find the patient likely to suffer harm because they will soon no longer have a place to live. For another example, let's say a patient is unable to address a medical condition, and now their health has declined so much that they need to be hospitalized. This may also be considered likely to suffer harm. Remember, the situation must be strong enough to say a patient's ability to make their own decisions should be limited by a court.
Now let's talk about incapacity. Note that a patient can also consent to a guardianship if a judge believes they have the ability to do so. But as you can imagine, this isn't very common. In general, before a court appoints a guardian, the court must find that the patient is incapacitated. This is a specific legal term. So when a court is deciding whether a patient is incapacitated, it will look at whether they can adequately understand and appreciate the nature and consequences of an inability to care for themselves. Now, this is pretty dense language, but essentially the court wants to know, does the patient understand the consequences of their decisions? Does the patient recognize that they need help? And do they understand the risks if they take certain actions or if they decide not to act at all? Let's look at an example. This is Bob. Bob is 75 years old and he has a cancer diagnosis. He spoke to his doctors about the benefits and risks of treating his cancer with chemotherapy. He understands that without chemotherapy, there's a chance his cancer will spread. However, Bob also had cancer 5 years ago, and the same type of chemotherapy made him really sick. After considering his options, his medical history, and what he wants in his quality of life, Bob decides not to pursue chemotherapy at this time. However, Bob's family disagrees with his decision, and they start saying that they think he's showing signs of early dementia. So they're thinking about starting a guardianship case so someone can consent to treatment. Let's think about this example. Bob understands the risks and consequences of declining treatment. He's already had treatment in the past. He's also making a conscious decision to choose quality of life over potentially extending his life. While this example is simplified, it does show how a guardian wouldn't be appropriate in this example because Bob isn't incapacitated. Bob's choice brings us to the dignity of risk. The idea that self-determination and the right to take reasonable risks are essential to a person's dignity. When we talk about guardianship, we're almost always talking about older adults and people with disabilities. And because of this, we have to look at how ageism and ableism color our judgment of people's decisions. Consider how you may react if an 80-year-old patient says they're going skydiving. Is it different if they were 30? If they get injured, do we call the 30-year-old a thrill seeker, but use the injury as proof that the 80-year-old can't live independently? It's really easy to equate a bad outcome with a lack of capacity. With the right to take a risk and to make mistakes, it's a fundamental part of being an adult. Our role isn't to eliminate every danger, but it's to ensure that the person understands the risks so they can decide for themselves. So also consider this. A patient with diabetes is found with a box of donuts. Now, if you're picturing a patient that's 80 years old, or maybe they have a developmental disability, are you jumping to cognitive decline or lack of insight? If a 25-year-old without a disability does the same, do they immediately get a pass and we call it a poor choice? When someone makes an unwise choice, ask yourself, is this a failure to understand facts or just a difference in personal values? Am I seeing a loss of capacity or just a life I wouldn't choose for myself? We see similar issues when it comes to communication. When a patient has difficulty communicating, they may be viewed as having decision-making limitations. But having communication barriers does not mean a person can't communicate, and it certainly doesn't mean they're incapacitated. To truly support informed decision-making, we must provide the right accommodations, whether that's an alphabet board, a quieter room, a certain time of day, or breaking down information into smaller steps. Bringing our attention back to the guardianship standard. Even if a court has found a patient is incapacitated, a judge will only appoint a guardian if no other services or tools are available to help them. So if your hospital or someone in the patient's life is seriously considering guardianship, please keep in mind that it must be used as a last resort because it takes away a patient's decision-making power. Alternatives like powers of attorney, healthcare proxies, community services like home care, support from family and friends, all those must be explored first. We discussed these and other alternatives in another video, and there are many resources related to alternatives in our companion document.
Now let's go over the guardianship process. Any concerned entity or person 18 and older can start a guardianship case. This could be a family member, a friend, adult protective services, or even the hospital itself. The person or entity bringing the case is called a petitioner. A guardianship case must be filed in the county where the patient lives. Since every county tends to be a bit different, it's a good idea to check with the local court first to find out if they have specific forms or procedures you must follow. The petitioner starts a case by filing documents explaining why the patient needs a guardian and why they meet the standard outlined earlier. If the petitioner has someone in mind, they can also name a proposed guardian. The petitioner must also pay a filing fee, but it's possible to waive this if someone cannot afford it. Once all the papers are filed, the court will set a hearing date. The hearing is supposed to be set within 28 days, but sometimes it can be longer depending on the court's schedule. Some hearings take place in person, and others might be virtual. At this point, the judge might appoint an attorney for the patient, but they don't always do this. The judge might also appoint someone called a court evaluator. This is a neutral third party who will investigate the information in the petition. They'll talk to all the parties involved and submit a report to the court with recommendations. But again, this doesn't happen in every case. Sometimes a patient has needs that are too urgent to wait for this process. Perhaps they are actively being financially exploited, or a decision needs to be made about time-sensitive medical treatment. In some urgent cases, a judge may appoint a temporary guardian who can act quickly to address these kinds of time-sensitive matters. The standard for appointing a temporary guardian is very strict because it gives a guardian decision-making authority and takes it away from the patient without even having a hearing. For more information on temporary guardians, consult the companion PDF. Now let's turn back to the regular guardianship process, assuming there is no temporary guardian. At the hearing, the petitioner needs to prove why the patient needs a guardian. This can be done with documents or witnesses. Possible witnesses could include family members, friends, social workers, and others who know the patient well. Hospital staff might also be asked to testify. If you are concerned about patient confidentiality, talk to your supervisor. After the petitioner presents their case, the other parties will have an opportunity to speak and present any documents or witnesses too, including the patient if they are able to participate in the hearing. The patient can have an attorney represent them to help advocate for their wishes. They can hire their own attorney, or they can ask the court to appoint one for them. Sometimes the hearing takes more than one day, or it can be rescheduled to a later date. This can happen if a witness isn't available, a court evaluator needs more time to investigate, or the court wants to allow more time to explore alternative options. This is part of the reason why guardianship cases can take so long. Once the judge has heard from everyone, they will typically decide at the hearing if the patient should have a guardian. If so, the judge will also decide who the guardian is and how long the guardianship will last. While the petitioner can ask to be the guardian or suggest someone else, the decision is ultimately up to the judge. In general, anyone 18 and over who the court deems suitable can be a guardian. The court prefers family members and friends as guardians, but if there isn't anyone in the patient's life who is willing and able to serve, the judge will select a paid professional if the patient has the means to pay for one. If the patient cannot afford a paid professional, the judge can appoint a nonprofit organization instead. The judge also decides what powers the guardian will have, which may be different than what the petitioner requested. It's important to note the guardian will only have the powers necessary to meet the patient's unmet needs. However, there are two powers a guardian will never be granted. A guardian cannot consent to substance use treatment or mental health treatment over a patient's objection. This includes psychotropic medication and admission to inpatient facilities. The judge will also appoint a court examiner who will review the guardian's reports and make sure the guardian complies with their duties. While the names are similar, the court examiner has a different role than the court evaluator appointed earlier in the process. All of this information will appear in a document called an order and judgment. If a guardian was appointed, they have to complete some administrative forms before they can start making decisions for the patient. And if the guardian isn't a professional, they will also have to complete an online training first. Thank you for joining us for this module. Before you go, here are some key takeaways. Guardianship is a legal arrangement that requires a full hearing. If a patient says they have a guardian, or someone says they are a guardian, ask if they have been to court and have any court papers. Article 81 of New York's mental hygiene law governs guardianship of incapacitated adults. A judge decides which decision-making powers the guardian will have based on the patient's unique needs. A court must find a patient is incapacitated first before appointing a guardian for them. It is also possible for a patient to consent to guardianship, but this is less common. Lastly, before a guardian can be appointed for an incapacitated patient, all less restrictive alternatives must be explored. We'll discuss these alternatives in another video. If you have more questions about Article 81 guardianship, please reach out to our helpline. We provide information to the public as well as professionals and are available by phone, email, and online.